On the morning of March 15, 2026, a legal document was hand-delivered to the chambers of a senior barrister in central London. It was not a routine filing. It was a notice of claim, the formal opening move in a defamation action that the Sussex legal team had been preparing for several weeks. The targets of that action were two of the most prominent and combative figures in British royal commentary. Tom Bower, the investigative biographer whose 2023 book Revenge had placed Meghan, Duchess of Sussex, at the centre of one of the most contested royal narratives in modern memory, and Lady Colin Campbell, author, commentator, and arguably the most persistent and outspoken critic the Sussexes have faced in the years since their departure from royal life. The claim, according to sources familiar with its contents, centred on allegations that both Bower and Lady Colin Campbell had made, in print, in interviews and across various media platforms, regarding the circumstances surrounding the births of Archie and Lilibet, the Sussex children. Allegations that Meghan's legal team described, in the language of the filing, as deliberately false, malicious, and calculated to cause serious harm to her reputation as a mother and as a public figure. The amount cited in the filing was significant. Sources placed the damages sought at somewhere in the region of £10 million. That figure was not an accident. In British defamation law, the size of a claim signals the seriousness with which the claimant regards the allegation. It is a statement of intent as much as it is a statement of harm. What Meghan's legal team may not have fully anticipated, or what they may have calculated differently than events have since suggested, is what happens next when you file a defamation claim of this magnitude. Because in British law, the moment you allege that someone has lied about you, you open a door. And what comes through that door is not always what you expected. That is the story we are going to tell you today. We are going to tell you who Tom Bower and Lady Colin Campbell are and what specifically they have said and published that triggered this legal action. We are going to explain carefully and precisely how British defamation law works and why the filing of this claim may have created exactly the situation Meghan's team was trying to avoid. We are going to tell you about the legal mechanism known as disclosure, the process by which both sides in a court case must hand over documents relevant to the dispute, and why, in this particular case, that process is being described by legal observers as a reckoning. And we are going to ask the question that this whole story keeps returning to. What does it mean when the simplest way to win a defamation case is to produce the evidence? If you want to stay with us on this story, and there is a great deal more still to come, please hit the subscribe button right now and turn on the bell notification. Every new video will come directly to you. We are genuinely glad you are here. Now let us begin. To understand why this legal action has attracted the attention it has and why it carries consequences that extend far beyond a standard celebrity defamation dispute, we need to understand the two people at the centre of it. Tom Bower is not a tabloid journalist. That distinction matters. He is an investigative biographer with a career spanning more than 4 decades, whose subjects have included Robert Maxwell, Richard Branson, Tony Blair, and Boris Johnson. His 2023 book about Meghan, titled Revenge, Meghan, Harry and the War Between the Windsors, was one of the most commercially successful royal books of the decade. It drew on hundreds of sources, many of them speaking anonymously, and painted a portrait of Meghan that was deeply unflattering on a number of fronts. The book was controversial from the moment of its publication. Meghan's team disputed many of its claims, but it was never successfully challenged in court, not until now. Lady Colin Campbell is a different kind of figure. She is a writer and broadcaster of aristocratic background. Her full name is Georgia Ziadi, and she took the name Campbell upon her marriage to Lord Colin Campbell in the 1970s. She has been a consistent and vocal presence in royal commentary for years, with a particular focus on the Sussexes. Her commentary has frequently been the kind that attracts legal attention, direct, unfiltered, and willing to go further than most mainstream outlets would consider. She has been sued before. She has, on previous occasions, successfully defended those suits. She is not a person who is easily intimidated by legal threats, and she said as much publicly in the days following the filing of Meghan's claim. Her response, delivered to reporters outside her London home, was 4 words: "Let them sue me." Those 4 words carrying everything that matters about her position. She believes she is on solid ground. She believes that the process of litigation, specifically the process of disclosure, will produce evidence that supports her claims rather than undermines them. And she has said so directly, which is not the behaviour of someone who fears what the courtroom will reveal. Now let us explain, carefully, exactly what is at stake in legal terms. Because this is where the story becomes genuinely significant, and where the implications extend far beyond the personal reputations of the people involved. In England and Wales, defamation law operates on a specific principle. If you publish something about a person that is false and damaging to their reputation, they can sue you. The person suing, the claimant, does not, in the first instance, have to prove that what was published was false. The burden in English defamation law initially sits with the defendant, the person who published, to demonstrate that what they said was true, or was a matter of honest opinion, or served the public interest. This is sometimes called the truth defence, and it is precisely this principle that makes Meghan's legal action so consequential. Because what Bower and Lady Colin Campbell have alleged, the specific claim that sits at the heart of this dispute, concerns the births of Archie and Lilibet. The allegation, which both have made in various forms across several years of commentary and publication, is that there are unanswered questions about whether Meghan carried both children herself. The specific language used in British law in relation to the line of succession is the phrase "born of the body." Under the Act of Settlement of 1701, the foundational constitutional document that governs who may succeed to the British throne, an heir must be a direct biological descendant of the monarch. The phrase "born of the body" has been interpreted consistently across centuries of constitutional practice to mean biological lineage. Bower and Lady Colin Campbell have alleged, in varying degrees of specificity across their respective publications and public statements, that the documentation surrounding both births contains anomalies. They have alleged that certain records that would normally exist, hospital documentation, medical signatures, Church of England baptism registrations, either do not exist in the form expected or have not been produced in response to legitimate questions. They have not, it is important to say, produced definitive evidence that Meghan did not carry her children. They have raised questions, persistent, documented, legally consequential questions, and Meghan's team has now, by filing this claim, placed those questions squarely in front of a court, and what the court will now require, what it must require under the rules of civil procedure, is disclosure. Disclosure, in plain terms, means that both sides must hand over all documents in their possession that are relevant to the case, not the documents they choose to share. All relevant documents. Documents that help their case and documents that do not. Medical records, hospital communications, birth certificates in their original unredacted form, correspondence between the parties and their advisors, any non-disclosure agreements that touch on the relevant period, all of it under oath, with legal sanctions for anything withheld. That is the legal trap that observers are describing. Not a trap set by Bower or Lady C, but a trap that the act of but a trap that filing this claim has created for the Sussex legal team. Because the moment you allege that someone has lied about your children's births, the court's first question is, show us the birth records, show us the hospital documentation, show us what actually happened. If those documents are complete, signed and fully consistent with the public narrative, The case against Bower and Lady C becomes, in legal terms, very strong. A defendant who has alleged falsehoods about a birth that is fully documented and provable faces a very difficult position. The claim would likely succeed, the damages would be significant, and the reputational damage to both writers would be severe and lasting. But if those documents are incomplete, if signatures are missing, if hospital records contain gaps, if the paper trail that normally exists for every birth in England and California does not exist in the form required, then the defence of truth becomes available to Bower and his co-defendant. And the very act of bringing the case to court will have produced, through the mechanism of disclosure, exactly the evidence that Meghan's team filed the case to suppress. Legal observers in London, speaking to various outlets in the second week of March 2026, described the situation with unusual directness. One senior barrister, speaking without attribution, said that any competent legal team would have known that filing this kind of claim creates a document production obligation that cannot be managed or controlled once it is in motion. The question, that barrister said, is whether the Sussex legal team filed this claim in the confidence that the documents exist and are clean, or whether something else is driving the decision. That is a question this script cannot answer. We do not know what the documents contain. We do not know what the disclosure process will produce. What we can say with certainty is that the process is now in motion, and the motion is not reversible. Let us take a brief pause here, because we have covered significant ground and there is considerably more still to come. If you are finding this story as important as we believe it is, we would ask you to pause for just a moment and share this video with someone who would appreciate having it explained properly. A friend, a family member, someone who follows this story and who deserves a careful and balanced account of what is actually happening. Sharing takes just a moment, and it helps us reach more people who want the kind of coverage that respects their intelligence. Thank you. Now let us continue. Tom Bower's response to the filing was not that of a man who believes he has been caught out. In the days following the delivery of the legal notice, sources close to his legal team confirmed that his response to the defamation claim was to file his own counter-documentation. Not a counterclaim in the formal legal sense, but a detailed response to the notice of claim that, according to sources familiar with its contents, outlined in considerable specificity the evidential basis for the claims in his book. That evidential basis, as reported by outlets covering the story in mid-March 2026, includes a number of specific items. A gap in the electronic security log at Portland Hospital in London on the day of Archie's birth in May 2019. A gap of approximately 4 hours for which no satisfactory explanation has been offered. A Church of England baptism register entry for Archie that, according to Bower's researchers, bears no original physical signatures of the officiating bishop or the attending godparents. Signatures that are required under Church of England guidelines for a valid baptismal record, and questions about the documentation surrounding Lilibet's birth at Santa Barbara Cottage Hospital in California in June 2021, specifically the absence of a discharge record matching the announced birth date in the hospital's publicly accessible medical waste and discharge logs. These are specific documentable claims. They are not, to be clear, proof of anything. The absence of a document is not the same as proof that something did not happen. Hospitals make administrative errors. Registers contain omissions. Medical waste logs are not infallible. Every one of these anomalies has an innocent explanation that is entirely possible. What they do not have, as of the date of this recording, is a documented, verified, court-ready, innocent explanation. And that is precisely the issue. Lady Colin Campbell, meanwhile, has been characteristically direct about her position. In interviews given in the days following the receipt of the legal notice, she stated that she welcomed the opportunity to test her claims in an open court. She stated that the documentation she had gathered through years of commentary and research was sufficient to mount a credible defence of truth. and she stated, with the directness that has always characterized her public persona, that if Meghan wanted to prove her wrong, the simplest thing in the world would be to produce the relevant medical records voluntarily, outside of any court process, and let the documentation speak for itself. That challenge, produce the documents and end the dispute, is one that the Sussex team has not yet publicly responded to. As of mid-March 2026, no voluntary disclosure of medical records has been made. The legal process is proceeding along its formal timeline, and the silence from Montecito, in the face of what would appear to be the simplest possible rebuttal, has not gone unnoticed. It is worth pausing on that silence, not to interpret it as guilt. Silence in a legal matter is often the result of legal advice, not of concealment. Lawyers almost universally advise clients not to produce documents voluntarily in advance of formal disclosure requirements because voluntary production can complicate the formal process. The silence may mean nothing more than that the Sussex legal team is following standard legal practice. But silence in the court of public opinion operates differently from silence in a courtroom. And in the court of public opinion, particularly the global social media-driven, opinion-saturated court of public opinion that the Sussexes have spent the last 6 years navigating, silence in the face of a specific documentable challenge tends to generate its own narrative. A narrative that, at this particular moment, is not a comfortable one for the family in Montecito. Let us now step back and look at the broader picture, because this legal action does not exist in isolation. It exists within a larger story about the Sussex family's relationship with the institutions and the individuals who have questioned their narrative over the past several years. Since their departure from royal life in January 2020, Harry and Meghan have engaged in a pattern of public disclosure that is, in its way, historically unprecedented for members of the royal family. The Oprah Winfrey interview in March 2021, the Netflix documentary series in December 2022, Harry's memoir Spare, published in January 2023. Each of these was, in its own way, an exercise in what their advocates described as radical transparency, a willingness to say publicly what the institution had always kept private. The argument they made consistently was that the old culture of royal silence was itself a form of harm, that keeping things hidden, keeping the pain hidden, keeping the racism hidden, keeping the institutional failures hidden, served the institution at the expense of the individuals trapped within it. That transparency, however uncomfortable, was ultimately more honest and more humane than the culture of managed silence. That argument has considerable merit, and many people, watching the events of the last 6 years, have found it compelling. But it contains within it a specific tension that this legal action has now brought into sharp relief. Because the argument for transparency cannot be selective. You cannot argue that the institution's silence about its own failures is a form of dishonesty, and then respond to specific, documented questions about your own narrative with legal action designed to shut those questions down. Transparency, if it is a genuine value rather than a tactical position, has to apply in both directions. That is not an accusation, it is a question. And it is a question that this legal action, whatever its outcome, has placed directly and unavoidably in front of the public. Now let us be precise. About where things stand as of mid-March 2026, for anyone who has joined us partway through this account. Tom Bower and Lady Colin Campbell have, across their respective published work and public commentary, raised questions about the documentation surrounding the births of Archie and Lilibet, the children of Prince Harry and Meghan, Duchess of Sussex. Meghan's legal team filed a defamation claim against both of them in mid-March 2026, citing damages of approximately £10 million. The filing has triggered the formal legal process of disclosure, a process under which both sides must produce all relevant documents, including medical records, hospital documentation, and correspondence relating to the alleged defamation. Bauer's legal team has responded by indicating that they will defend the claim on the basis of truth, meaning they believe the evidence supports what they have published. As of this recording, no voluntary disclosure of medical records has been made by the Sussex side. The formal disclosure timeline is proceeding. The financial stakes for the Sussex family are considerable. The commercial architecture that Harry and Meghan have built since 2020, the Netflix deals, the speaking engagements, the lifestyle ventures, the brand partnerships, is built in significant part on the continuation of their royal identity. The titles of Duke and Duchess of Sussex, the HRH styles, the identification of their children as Prince and Princess. These are not merely honorific. They are the foundation of a commercial proposition that analysts have valued at its peak in the region of £150 million. A defamation case that ends with a finding against the claimant, meaning a finding that what Bauer and Lady C published was substantially true, would not merely be a legal defeat. It would be, in the language of commercial risk, a material reputational event, the kind that triggers review clauses in broadcasting, contracts, publishing advances, and brand partnership agreements. The kind that changes everything. None of this is certain. Legal cases of this complexity take months, sometimes years to resolve. The disclosure process has barely begun. Outcomes are genuinely uncertain, and this script makes no prediction about how the case will ultimately be decided. What we can say is that the decision to file this claim, whatever its legal merits, has created a situation of considerable and escalating risk for the people who filed it. Why, then, was it filed? There are honest answers to that question that do not require anyone to be cast as a villain. The first is emotional. Meghan has said in multiple public contexts that the allegations about the births of her children are the most painful thing that has been written about her, not the claims about her personality or her relationships or her career. The allegations about her children, the suggestion that she did not carry them herself, that the connection between a mother and her children, the most intimate and irreducible human bond, has been fabricated. If those allegations are false, the emotional imperative to fight them in court is not difficult to understand. It is, in fact, deeply human. The second reason is strategic. By filing the claim, the Sussex legal team may have calculated that the reputational damage of allowing these allegations to circulate unanswered, in books, in interviews, on social media, had reached a threshold where legal action was the only remaining tool for containment. The alternative, continued silence, was itself generating a narrative of implicit admission. Sometimes a lawsuit, even a risky one, is filed because the cost of not filing is considered higher. The third reason, and perhaps the most significant, is that the legal action may have been intended as a deterrent rather than a genuine proceeding. In British law, the receipt of a legal notice from a well-funded claimant carries costs and risks for the recipient, even if the recipient ultimately prevails. The intention may have been to signal to Bauer, to Lady C and to others with similar inclinations that the cost of pursuing these allegations would be high. A calculated use of legal process as a form of reputational management. Whether any of those calculations will prove to have been correct depends in the end on the documents. Because that is what this story, stripped of all its drama and legal complexity, ultimately reduces to. Documents, birth records, hospital logs, baptism registers. The paper trail that exists for the arrival of every child into the world, royal or otherwise. Simple, factual, verifiable documentation. If those documents are complete and clean and fully consistent with what has been said publicly, Meghan wins. The case is strong. The defense of truth fails. The allegations are put to rest. If those documents contain the anomalies that Bauer and Lady C have described, the missing signatures, the unexplained gaps, the administrative irregularities, then the case takes on a different shape entirely. one with implications not just for this lawsuit, but for the constitutional question of the children's position in the line of succession. That is the legal reality, and both sides of this dispute know it. What comes next, in the weeks and months ahead, will be determined by the pace of the formal disclosure process, the willingness of medical institutions in both London and California to respond to court-ordered document requests, and ultimately by the contents of the records themselves. The court timetable, once set, is not easily adjusted. The disclosure obligations, once triggered, are not easily avoided. The world will learn what those records contain, not through the media, not through social commentary, through the formal, documented, court-supervised process of civil litigation. In that arena, what matters is not what you have said publicly. It is what you can prove privately, and somewhere between those two things, between what has been said and what can be proven, lies the truth that this entire story has been circling for years. There is a particular kind of sorrow in this story that goes beyond the legal mechanics, beyond the filings and the disclosure timelines and the constitutional implications. Archie is 6 years old. Lilibet is 4. They did not choose any of this. They were not there when the decisions were made about how to tell their story to the world. They were not consulted about which records to produce and which to withhold. They are children, ordinary, beloved, completely innocent children who happen to carry extraordinary names in an extraordinary family at an extraordinary moment in history. Whatever the outcome of this legal action, whatever the documents reveal, whatever the court decides, those two children will one day read about this. They will read about the questions that were raised about the most fundamental fact of their existence, about whether their mother carried them into the world, about whether their grandfather's lawyers asked questions about their birth certificates, about whether a courtroom in London spent months examining the paper trail surrounding their arrival. That is a heavy thing for a child to carry. However it resolves, Meghan is fighting this case, at least in part for them, for the right to have her children's births treated as the straightforward, joyful, unremarkable human events that every birth should be. That motivation is real, and it deserves to be acknowledged without cynicism. And Tom Bower and Lady Colin Campbell are pursuing their case, they say, in the interest of a truth that they believe matters constitutionally and historically. That motivation, the idea that the line of succession to the British throne is not a matter in which inaccuracy can be permitted, is also real, and it also deserves to be acknowledged without dismissal. Two sets of people, each believing they are on the right side of this question. A court process that will, in time, tell us which of them is closer to the truth. And two small children whose names have become the terrain on which that question is being fought. She will carry it, because that is who she is. Whatever else one thinks of the choices Meghan has made, the interviews, the memoir, the legal filings, no one who has watched her speak about her children has ever doubted the love. That love is not in question here. It has never been in question. What is in question is the record, and the record now is a matter for the court. Thank you so much for staying with us through every part of this story today. It is a complex one, legally, constitutionally, and humanly, and we are grateful for your patience and your thoughtfulness in following it with us. We want to ask you a very specific question in the comments below. Here it is. Do you believe Meghan made the right decision in filing this legal claim, even knowing that it triggers a disclosure process that could produce unpredictable results? Or do you think the wiser course would have been to let the allegations go unanswered rather than bring them into a courtroom? There is no simple answer to that question, and we would genuinely love to know where you stand. We read every single comment, and your perspective matters deeply to how we cover what comes next. If you are not yet subscribed to this channel, please take a moment right now, click subscribe, turn on the bell, and join a community that follows these stories with care, with balance, and with the deep respect for your intelligence that you deserve. We will see you in the next one. Thank you so much. We will see you very soon.